What is going on, everyone? It is me, the Lone Vault Wanderer, here with a video on let's playing video games and streaming video games in their relation to fair use under copyright law. Over the past couple of days, there's been a lot of debate, a lot of controversy over Persona 5. So Atlas had actually imposed guidelines or requirements over people that wanted to stream the game and upload video content of the game. And I'm not going to get into the specifics of what they said people could and couldn't do with regards to the video game. But what I saw, and there's been a lot of discussion about this, is that people in response to this, of course they were very angry, was saying that no, let's playing video games is okay under fair use. That's fair use, you can't do this, how are they allowed to do this, etc, etc. And there is a lot of misunderstandings about how copyright law actually works, and more to the point, how fair use actually works as a legal concept. There is a lot of misunderstanding of fair use in particular, and I wanted to create this video to try and clear up things as much as possible. And I think it's relevant, particularly because of this recent Persona 5 controversy that happened. And I believe that I can sit here and make a video on this topic trying to explain it as much as possible, because as some of you may know, my full-time occupation is that of a lawyer. I'm a fully qualified lawyer in the Supreme Court in one Australian state, I won't say which one it is, and in my actual job, I deal with copyright law from time to time. So I feel like I have enough of a knowledge on this subject at a legal level, bear in mind the fact that I have a bachelor's in laws, and also as well I've worked for several years in the legal space, to at least have a video which describes at a very layman's level what copyright law and what fair use is all about. But I do need to stress that I'm certainly not an expert on copyright law. What people need to understand about the law is that it's a very, very complex field. And there are so many different pieces of legislation out there, and there are so many different pieces of case law that come together to form what the law is, that no one lawyer can know everything. It's almost impossible. This is why we have lawyers that specialize in different areas of the law. So for example, intellectual property law / copyright law, consumer law, family law, criminal law, etc. You have lawyers that build up their practice specializing in specific areas of the law because the market demands that. There is so much law to understand and to apply, even within particular topics such as copyright, that it's actually better if a lawyer completely dedicates their time to that particular topic. That's where you get specialities. That's where you get specialist solicitors and specialist barristers. Of course, you do have solicitors and barristers that are generalist and work in different areas of the law, but the point that I'm trying to get across is that I'm certainly not an expert or a specialist in copyright law. I've dealt with it in my job from time to time, and I've done some further research on it. And even more so, I'm dealing with Australian law in my job, not with United States law. And even with copyright law between the US and Australia, things do differ a lot. For example, we don't have fair use here in Australia. We actually have a different, more restrictive concept of fair dealing. So also bear that in mind when I'm talking about fair use and I'm talking about United States law. I'm talking about an area that I'm not an expert in. I'm talking about a country's law that I don't practice in and that I don't read and look at every day. And I'm also talking about a legal concept in fair use that is different to the concept that exists in my home country. Of course, in Australia, there are reforms looking to bring in fair use into the country, but honestly, that is probably several years away. So bear that all in mind when you listen to my discussions and hear me talk about fair use and copyright law in the United States context. And finally, one more thing that I need to stress, do not take this video and the things that are said therein as legal advice or as a substitute for legal advice. This is just guidance. This is for the most part me feeding back the law. This is not intended to be, nor should it be received as proper legal advice. If you do have concerns with regards to your own Let's Plays or your own video content, you should really consider hiring or getting the advice of a lawyer in your own country. That is absolutely paramount. So with all of those considerations out of the way, let's talk about US copyright law and let's talk about fair use and how it potentially applies to let's playing and streaming video games. So at the forefront, I need to say this. People that say let's playing video games and streaming video games is covered under fair use, is okay under fair use, are just plain wrong. It is not as clear cut as that. To my knowledge, we have not had a case that has come to any US court that has dealt with the issue of a YouTuber or a Twitch streamer let's playing video games and the question of whether fair use applies in those circumstances being raised. We have not had that. There is actually no precedent with regards to fair use and let's playing video games. So people that say that it's covered under fair use, that's actually technically wrong for now because there's no case law to back it up. There is no precedent to back that up. Let's playing video games operates in a very legally grey area of the law. We do not yet have clarity as to whether the act of let's playing a video game and uploading that video content to YouTube or streaming it directly on Twitch, whether that would be encompassed within the exception to copyright infringement of fair use. So bear that in mind. There is nothing in the courts, and mind you, there's nothing in legislation that says let's playing video games is covered under fair use. That is not true, so please bear that in mind at the top of this. So before we actually get into fair use and how it looks like under copyright law in the US, let's consider how video games are copyrighted. Now, for simplicity, in this video, I'm going to be talking about video games in and of themselves as copyrighted work. But in fact, that's not exactly how video games are copyrighted. This is where things tend to get a little bit tricky. If you actually look at US law, and specifically the US Copyright Act, there is nothing that says a video game per se, or a video game as such, is copyrightable as a film may be, or as other works may be. You actually can't copyright a game as a whole, as a concept. For example, you can't copyright Fallout as a game. You can trademark the name Fallout for the game, but trademarking is a separate concept. Fallout as a game isn't necessarily copyrighted. What is in fact the case is that the game Fallout is made up of many different copyrightable elements that all form together to create the game Fallout. And why is this the case? Well, if you look at section 102 of the US Copyright Act, which is entitled Subject Matter of Copyright in General, the section reads as follows: copyright protection subsists in original works of authorship fixed in any tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated. Works of authorship include the following categories, and it lists things like literary works, musical works, motion pictures and other audiovisual works, and sound recordings, things like that. So look at that list, and you can't see anything that refers to video games. You see motion pictures, but nothing about video games. So here's the second important point that I want you to bear in mind. While in this video, again for simplicity, I'll be talking about video games in and of themselves as a copyrighted concept, video games contain many different elements. They contain music, they contain graphics, they contain the source code for the video game. So many different things that come together to create the video game, each individual element of which is copyrightable. So for example, the underlying code, the source code for a video game, is actually considered as a literary work. As another example, all of the pictures, all of the video recordings, all of the sounds, all of the music, all together in a video game, they're considered audiovisual works or audiovisual elements. So you can see that while the game itself isn't necessarily copyrightable, it's made up of works that are copyrightable, such as audiovisual elements, textures, meshes, voice character work, sound effects, things like that. They all come together to create the game. And also, of course, the source code as a literary work. People need to understand that's how video games receive protection under the US Copyright Act. So just bear that in mind when I talk about video games being copyrighted. I'm actually referring to the individual elements that build up a video game being copyrighted themselves. Alrighty, so let's say you have a video game that is copyrighted. What rights does the owner have over that work? And with video games, we're typically talking about the developer of the game or the publisher of the video game. So for here we go to section 106 of the Copyright Act, which is entitled Exclusive Rights in Copyrighted Works. Subject to sections 107 through 122, the owner of copyright under this title has the exclusive rights to do and to authorize any of the following. Then I'll list a number of things like, for example, to reproduce the copyrighted work in copies of phonorecords, to distribute copies or phonorecords of the copyrighted work to the public by sale or other transfer of ownership, or by rental, lease, or lending, things like that. So these are actually the copyrights. This really forms the heart of copyright law and what owners can or cannot do with their own copyrighted material. So for example, this section allows a game publisher to sell their video game and make a profit off of it. And the important point to bear in mind is that these are exclusive rights to do. So it means that with regards to a video game, aside from the publisher or the developer, the owner of the video game itself, no one else, including Let's Players, has any of these rights with regards to the video game. Now, mind you, the owner of the video game also has the exclusive rights to authorize any of the following. So for example, if we're talking about Let's Plays here, look at subsection 2, to prepare derivative works based on the copyrighted work. Generally, Let's Plays are going to be considered derivative works. You're recording footage of a video game, or you're Let's Playing it, uploading it to YouTube, or putting it on Twitch. That is producing a derivative work based on that video game, which is a copyrighted work. So publishers and developers, the owners of games, actually have the right to go to different streamers and under a licensing agreement or similar, can say, you are allowed to Let's Play this video game. You are allowed to stream this video game. You are allowed to create all the video content you want with regards to this video game, because they have the exclusive right to authorize the preparation of derivative works. So yes, owners of games, they have the right to say, you can only produce a Let's Play or do a stream of a game if you follow our guidelines or if you follow these requirements. So generally, those are the copyrights, those are the exclusive rights that exist when you own a copyrighted work like a video game. But now we go to fair use. And really, this is what this video is all about. I know that I've spent a long time rambling before that, but that's been really important context to be able to understand fair use here. So fair use, section 107, limitations on exclusive rights, fair use. Just read that title, limitations on exclusive rights. I've just listed to you and discussed the exclusive rights that game companies have over the video games they own. This section is talking about limitations on those exclusive rights, exceptions, if you will. So it says the following, notwithstanding the provisions of section 106 and section 106A, which again, section 106 contains all those exclusive rights, so this is acting as an exception to section 106. The fair use of a copyrighted work, including such use by reproduction in copies or phonorecords, or by any other means specified by that section, for purposes such as criticism, comment, news reporting, teaching, scholarship or research, is not an infringement to copyright. So let's talk about fair use as a concept before we even get to the determining factors that are listed below. Let's be very clear here. Fair use is a defense. It is an exception to infringements of copyright. When people on the internet, such as for example with regards to Persona 5, say that no, they're not allowed to do that, this is considered fair use. Let's playing video games or streaming video games is considered fair use. That's not how fair use is used. That's not really the purpose behind fair use. There's a long-standing phrase or notion in law generally of the shield and the sword. And when we're talking about fair use is what we would consider a shield, not a sword. It is a source of defense, not a source for attack. So to explain further, fair use will apply when a case goes to court. For example, someone infringes copyright, the copyright owner takes them to court. The copyright owner will say, this person infringed the copyright in my work. At that instance, can then the person that's being brought to court say, well, yes, I infringed your copyright. However, there is a defense here. There is an exception in the form of fair use. If my infringing use of your copyright material was fair, then it's not considered an infringement of copyright. So as you can see, it's being used as a shield to protect against claims of infringement of copyright. It's very subtle, it's very nuanced, but you need to understand that's how fair use works. Alrighty, so what does it actually mean? What does fair use actually mean in relation to copyright material? So because we're talking about Let's Playing video games, let's use that as an example. Again, video games are copyrighted, right? They have a copyright owner, they're made up of different individual copyrightable elements. When you Let's Play a video game or stream a video game, if you just consider section 106, you are technically infringing copyright because you're producing a derivative work of that copyrighted content. However, section 107 then steps in and says, if that particular use in creating a Let's Play or streaming a video game was fair, then it's not an infringement of copyright. So that's how fair use operates with regards to using copyrighted material. And section 107 actually gives a few illustrative examples of what may be considered fair use. For instance, criticism, news reporting, teaching, If the use of copyrighted material falls in one of these categories, then it points more so towards the use of that copyrighted material being fair. And these concepts such as news reporting, teaching, criticism, etc., they actually exist in Australian law too with regards to fair dealing. There's certain predefined categories that over the years, due to case law and judgments, have generally been considered as typical uses of copyright material that are fair. However, bear in mind, just because your video on YouTube, etc., is criticism or involves criticism, involves news reporting, involves teaching, involves research, etc., that does not necessarily mean that the use will be fair. That is just an illustrative example of a use that may be considered fair. What is actually determinative here to see whether a particular use of copyrighted material is fair is by considering these 4 factors that are listed in section 107. These are otherwise known as the fairness factors. So let's read the section. In determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include 1. The purpose and the character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. Number 2. The nature of the copyrighted work. Number 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And finally, number 4. The effect of the use upon the potential market for or value of the copyrighted work. So how are these 4 factors considered? If a case is taken to court over let's playing a game or streaming a game, and the person being accused of infringing copyright relies on fair use as an exception, as a defense, again as a shield, the court will look at the particular use of copyrighted material, look at all of these factors, and weigh them together as a whole to determine whether the use is considered fair, whether it is a fair use and therefore the use is not considered to be an infringement of copyright. So a judge will look at a let's play of the video game and then apply that let's play to each and every one of those factors and on balance come to a decision as to whether that let's play of a video game is considered fair under the law. And before we go into the specific factors and what they each mean, something is very important to bear in mind here. Even if a case is taken to any US court over let's playing a video game or streaming a video game, whatever conclusion is reached or whatever judgment is reached, that is not ever going to be a hard and fast rule for let's playing video games or streaming video games as a whole, because the determination of fair use is done so on a case-by-case basis. It's done so according to the very specific facts of the case at hand. For example, if there's a particular video that's uploaded to YouTube that is taken to court over, that's a let's play of the video game, the court is going to look at that very specific video and ask whether that very specific use was fair. The decision is going to be confined to those very specific facts, to that very specific case. And even let's say in that instance that the let's play of the video game was in fact considered fair, that is not going to mean that every single let's play out there is always going to be considered as fair use if it's taken to court. Because let's plays, let's be honest, vary so much. They are so different from YouTuber to YouTuber, from Twitch streamer to Twitch streamer. Some let's plays are very long form. They are up to 30 minutes, even up to an hour long, maybe longer, and they don't involve that much editing. They're much longer in their segments. Whereas there are other let's plays that are much shorter, that are much more edited. There are much more jump cuts. There is much less of the game being shown. So because of how let's plays can vary so much, the question of whether a let's play of a video game is considered fair or not is always going to come down to the specific let's play at hand or the specific Twitch stream at hand of the video game. So even if we had a test case go to the US court, we are likely still going to be in a very legally grey area of the law. And all that one case is going to do is be a helpful precedent to help determine the results of other cases. But if the decision is very confined to a let's play where, for instance, the let's play is very highly edited, there's a lot of jump cuts, there's not that many cut scenes shown, it's under 10 minutes, etc., etc., that decision, that conclusion might be helpful in determining the case for other let's plays and other streams, but it can't just be copied and pasted to the case of a very long let's play that's much more different in its use of copyrighted material. So please bear that in mind. Even if we get a case that goes to court, it's not going to result resolve much. Alrighty, so let's look at each of one of these fairness factors and explain what they're all about. And when a court looks at these factors in relation to a let's play or a stream, they're going to apply the factors to the let's play or the stream and balance them all as a whole. Each of these factors have relatively equal weight. They're going to be looking at all of the factors, balancing them up, and then coming to an overall conclusion about whether the use is fair. So the first one, the purpose and character of the use. So essentially here for a let's play of a game, the court's going to be looking at the person doing the let's play and asking whether the use of that let's play in creating the video content or creating the stream is of a commercial nature or is non-profit. Now, of course, as you know, when you upload let's plays of games to YouTube or even stream them to Twitch, you can either do so on an unmonetized basis where you're receiving no revenue, where you're having no ads placed over your video or stream, and you're not receiving a single cent of that let's play, which would be considered as a not-profit use. Or you can monetize the let's play, or you can monetize your stream, or you can receive compensation in other manners, such as through Patreon, or such as through Twitch donations or Twitch subscriptions. And that would be considered a use of a commercial nature. And courts tend to consider uses that are not profit as fair use, as opposed to uses that are of a commercial nature and that are receiving income. Now, mind you, this does not mean that any let's play that's receiving money is not going to be considered fair use, because the courts in the past have found instances where money was made from a use of copyrighted material, being commercial that is, and still was fair. And that's because, one, this is just one of 4 factors that's weighed together a bunch of other different things and a conclusion is made at the end. But 2, it's not saying here that if a use is of a commercial nature that it can't be considered fair use. Courts would just tend to lean that way, but it's not definitive. Also as well, this does not mean that a non-profit let's play, a let's play where there's no monetization and there's no income coming in, that does not mean that that let's play will definitely be considered as fair use as well. Because again, it's just one factor. Sometimes you may have a non-profit use of copyrighted material that's not considered fair, and you might have a commercial use of copyrighted material that is considered fair. This is just balanced against many other factors. Now, importantly here under this factor, transformative uses of copyright material are more likely to be considered fair. And we hear this word being used so much with regards to let's plays and streaming. The argument is, because me as a streamer or as a YouTuber, I'm let's playing this video game or I'm streaming this video game, I'm recording my voice audio over the game, I'm providing commentary, I'm providing critique, I'm actually adding something to the game, I'm showing my experience of me let's playing this game. People have argued that that is a transformative use of the copyrighted material of the video game. That you are actually creating something different by doing the let's play and by putting your voice audio over the gameplay and by showing your experience of playing the game. So that's what people argue, and essentially transformative uses are uses that add something different, that add something new with a different purpose. And importantly, don't substitute for the original use of the work. So really the factor to consider here is, would people be watching my let's play or my stream of the game in substitution to going out and buying the game and playing it for themselves? Because if there is that substitution effect there, if they're not playing the game because they're watching that let's play or watching that stream, there's an argument there that the let's play or the stream is not transformative because it's not adding enough so as to not substitute for the original use of the work, that being playing the video game yourself. So those are questions that must all be borne in mind. The second factor, which is more quick we can consider, is the nature of the copyrighted work. And what do we mean by nature here? Well, at one end of the spectrum, we have unpublished works, entirely private works that have not been published to the public. If I create a video game and don't publish it and it's entirely private, that is at the spectrum that it receives the most protection under this factor. If my use is of that unpublished private copyrightable work, it's much less likely that my use of the material is going to be considered fair. Also as well, like a video game or a movie, if a work is more creative or is more imaginative, then that is also less likely to support the basis of a fair use. And then at the other end of the spectrum, you have very factual work, like as a technical news article or historical content or biographical content, things like that. So video games sit in the realm of creative and imaginative works. And because of that, because of the nature of the copyrighted content of video games as being creative and imaginative, it's going to be a little bit harder to prove and support a claim of fair use when you're doing doing a let's play of that game or when you're doing a stream of that game. So that's that factor. And now we get to the third factor, amount and substantiality of the portion used in relation to the copyrighted work as a whole. So here, courts are going to be looking at 1, the quality of the copyrighted material that was used, and also 2, the quantity of the copyrighted material that was used. Now, seemingly logic would dictate here that the more of the video game that you use, the less likely that fair use would apply, and conversely, the smaller amount of the game that you use in your let's play or stream, the more likely that fair use is going to apply. But that's not necessarily true either, because in some contexts, courts have found the use of an entire work, such as for parody purposes, to be considered fair under certain circumstances. Also as well, some courts have found that using a very small segment of a copyrighted work is not considered as fair use if it relates to a very important section or part of the copyrighted material that's otherwise referred to as the heart of the work. If your let's play, even if it's very small, relates to the heart of the video game, the most important part or parts of the video game, it may be less likely that fair use applies in that circumstance. So for example, that could be cutscenes, that could be story spoilers, that could be anything that relates to the most important facets of the game. The most obvious example that you can give there are story spoilers and plot twists. So with this factor, not only is a court going to be looking at a let's play or a stream and asking how much of the video game was used in relation to the copyrighted work as a whole. So for example, if a video game is 10 hours long and it's a 1 hour let's play of that video game, that's 1 hour of the copyrighted work used in relation to the 10 hours as a whole. They're going to be looking at the amount of the copyrighted work of the game being used in the let's play or the stream, and also as well the quality of the work used. So regardless of whether it's long or short, if the let's play is showing the key important elements of a video game, such as major story elements, major cutscenes, etc. to that nature, then it's less likely there that fair use is going to apply. And then alternatively, if my let's play is incredibly long, but doesn't really include cutscenes, doesn't really include story elements, and is just really raw gameplay, then that might point to fair use being applicable in those circumstances. So that's that factor there. And finally, the fourth factor, the effect of the use upon the potential market for or value of the copyrighted material. The courts are going to ask here, with regards to a let's play, whether that use harms the market, whether existing or the future market, for the copyright owner of that video game. So is it going to be the case that let's playing the video game or streaming the video game, is that going to hurt the market for the work? Like by hurting sales, for example, or by undermining income or even potential income? So in other words, with regards to let's plays, if people are watching my let's play of the video game or watching my stream, how likely is it that those people are going to go out and buy the game still, even after watching my let's play or stream, or not do so? Because if it is the case that by watching my let's play or by watching my stream, those viewers do not buy the game because they've watched that let's play or because they watched that stream, that's going to point against fair use applying. However, if the work is transformative and when people watch the let's play or the stream, it does not affect their decision of whether they're going to be purchasing the game, it does not really affect their decision of whether they're going to play the game themselves, then that's a factor that's pushing towards fair use applying in that circumstance. And to conclude with those four factors, again, with regards to let's plays, it's going to depend on the specific let's play and whether that specific let's play or stream is considered fair use. It's going to depend on the circumstances. Let's stress that. And I've actually had a conversation with an expert in US copyright law, and I asked him this exact question, and he told me that if this was brought to a court, there would be a very focused inquiry on whether or not the length or the quantity of the copyright material used in the let's play or stream was justified by the transformative purpose of the use. But he said that on the assumption that the let's play was largely non-substitutable. Again, that people aren't not playing the video game because they watch the let's play or because they watch the stream. And assuming as well that there's significant value added from the standpoint of the viewer. So when the viewer is watching a let's play or stream, is there value added? Is it transformative? Is it just straight gameplay and very little commentary, very little critique or experience from the let's player him or herself? Or is there a lot of commentary? Is there a lot of value added? Is it clear from watching the let's play that you're really enjoying the let's player's experience of the video game rather than the video game itself, and using that stream as a substitute for you playing the video game yourself? That's going to be one of the key inquiries that happens if this is brought to court. All right, so we got to the end of this. I've recorded for 50 minutes on my end, so let's see how short I make this. But as you can see, copyright law is incredibly complex, okay? And this is me saying it as someone that, again, is not an expert and that certainly has not delved into the hundreds of different case law that apply with regards to fair use. And you can also see that the question of fair use in relation to video games and let's playing and streaming very much depends on the specific let's play at hand, or the very specific facts or circumstances at hand. Unless law is explicitly changed to say that let's playing video games is okay under any circumstance, it's always going to be considered fair use, we are always going to be operating in a legally grey area of the law here. So anyways, guys and girls, I hope I've been useful. I hope it's been useful with listening to a lawyer's point of view on fair use copyright law in the United States. Again, I stress, do not take this as a substitute for legal advice. If you are stressed about your own content, or about your own YouTube channel and the let's plays that you're doing, or the streams that you're doing on your Twitch channel, seek out independent legal advice from someone within your own jurisdiction, okay? I'm stressing that right now. Anyways, that's all from me. This has been the Lone Vault Wanderer. Please take care of yourself, and would you kindly keep fighting the good fight.